Welcome, everyone, to our last webinar for 2023. It's hard to believe we're already in December, and this is our last one for this year. But today we're going to do our annual case law update. So you're going to find out what the courts and the CAT have to say about shared facilities, oppression, status certificates, reasonable steps to address noise complaints, CAT's jurisdiction regarding noise complaints, harassment, obtaining compliance in light of substance abuse. And of course, a case law update would not be a case law update if we didn't have a case or two about pets and support animals. So we're going to be covering all those topics today, and we've got a great lineup of speakers who are going to be joining us. For those of you that don't know me, I'm Sonja Hodis. I'm one of the many CCI directors, CCI Huronia directors, and I'm a condo lawyer and your moderator for today's webinar. But before we get started, I want to take this opportunity to thank our sponsors. And as I've said at all of our webinars, and it hasn't changed now, without the support of our sponsors, we are not able to put on these webinars free of charge for you. So we want to thank Integrity Property Management, Nordic Windows and Doors, and Select Path Insurance for sponsoring today's webinar. Also, we have some great news. If you didn't make it to our last webinar, you didn't hear the big announcement, but we are now approved for CMRAO CPD credits. So if you're a property manager in Ontario and you are looking to get CPD credits, this webinar is approved for one CPD credit. What you need to do is watch the webinar today live, and you need to put your name and company name in the chat box to confirm your attendance at the webinar today. And that will be our record of attendance for verification purposes for CMRAO. Last month's webinar was approved as well. There seems to have been some problems with the CMRAO website in terms of claiming your credit for last month's webinar. Some people have been able to do so. Some people have had some problems. But if you have any issues with claiming your credits, please reach out to CMRAO. They can help you in terms of getting that logged into your account. But we can confirm that we were approved for that credit last month. So if you're still having issues, feel free to reach out to us as well at admin@ccihuronia.com. We'll see what we can do to help you. But there seems to be some technical problem on the CMRAO website with respect to that. But don't forget to log today's webinar. It is approved, and we are going to be seeking approval for all of our webinars in 2024. And we will be indicating on our registration page if approval has been granted. So these webinars are a great way to collect your CPD credits at no cost to you, thanks to our wonderful sponsors. So who is CCI? Well, CCI is the Canadian Condominium Institute. We are an independent nonprofit organization formed in 1982. We have chapters across the country, 8 alone in Ontario. CCI Huronia is one of those Ontario chapters. Our main objective is education. However, we also advocate for condos, and we represent all those involved in condos, from owners to directors to professionals, and we encourage all of these stakeholders to work together. If you're not a member of CCI and you want to experience the benefits of membership, check out one of your local chapters and consider joining today. You can find a local chapter on our national website, cci.ca. And if you want to become a member of CCI Huronia, and we would love you to be a member of our chapter, just go directly to our website, ccihuronia.com. You can fill out your membership form and pay online on our website. In addition, CCI has a national resource center, which has information and materials from our chapters across the country, from coast to coast. And you can access that resource center on the national website, cci.ca, or on our website, ccihuronia.com. And while you're on our website, don't forget to check out our newsletter, Condo Buzz. And we are also on Facebook and LinkedIn, so make sure you join our pages and follow us there. And all of our webinars are also available on YouTube, as well as our website under the past webinars recording tab. So this webinar is going to be posted in about the next 7 to 10 days. But if you're watching these webinars on YouTube, which I encourage you to do, make sure you hit the thumbs up button, show us that you like the video, share it with anybody that you think might benefit from it. And don't forget to subscribe and hit the bell so that you know when we post new videos. We are working hard to try to get to 1,000 subscribers, so you can help us by subscribing to our YouTube channel. And our usual disclaimer, don't forget that the information that you're going to hear today is general information, and it may not apply to your specific fact situation. So if you are a condo director and you want to use the protection of Section 37 of the Act, you're going to need to get an opinion about your fact situation from your own professional. This webinar is not intended to provide you with opinions that would protect you under Section 37 of the Condominium Act. In addition, all the information provided today is current as of December 15th, 2023, but this webinar is recorded and you may be watching it at a later date and things may have changed. So make sure to check with your professional to confirm that the information is still current. And if you're watching us from out of province, please make sure you check with your professionals in your province to make sure that what we're discussing applies in your province as well. So all references to the Condo Act or any legislation in today's webinar will be references to Ontario legislation. So just a reminder again to property managers, if you want to claim your CMRAO credit, make sure that you put your name and company name in the chat box so that we can record that you attended today's webinar. So let's get started with our cases. We've got three great condominium lawyers with us today, Natalia Polis, Ashley Winberg, and Katya Ukrainetz. They're going to join us today and talk about these cases. And we're going to start off with Natalia, and you're going to talk about CAT's jurisdiction regarding noise.
Yes, thanks, Sonja. So good afternoon, everyone. The first case I'm going to be discussing this afternoon is the case of D. Domenico and Halton Condominium Corporation number 118. So as Sonja mentioned, this was an application before the Condo Authority Tribunal, everyone's favorite tribunal, of course. In this case, the applicant alleged to be hearing sounds of rushing water for intervals of approximately 5 minutes to an hour. In response to the applicant's complaints, prior to the application being commenced, the condo took some steps to investigate and try to determine the source of the problem. So they retained various plumbers and also acoustical engineers. The condo also took some steps to try to reduce or eliminate these alleged rushing water noises. Some of those steps included disconnecting and rebalancing the jets to a bathtub in a neighboring unit, replacing or modifying a number of older faucets and shower heads in other units, and also made some modifications to the applicant's unit itself. In 2019, the condo's acoustical engineer reported that the noise levels within the applicant's unit were actually within acceptable levels per the ASHRAE guidelines. Despite this finding, the applicant commenced this application. In the application, the condo argued that the tribunal did not have the jurisdiction to hear the dispute as it pertained to the corporation's repair and maintenance obligations pursuant to Sections 89 and 90 of the Condo Act. And the tribunal does not have jurisdiction over those sections. The condo also argued that it had already addressed the applicant's complaints, and even if it had not, the remaining noise was not a result of the activities of another person, but rather was a function of the condo's plumbing systems, which it did acknowledge was aging. The condo brought a motion to dismiss the application, although regrettably a little bit late in the application process itself, on this basis that I just mentioned. Ultimately, the CAT agreed with the condo and dismissed the application in its entirety, relying predominantly on earlier cases that found that the tribunal does not have jurisdiction over maintenance and repair disputes. CAT agreed with the condo that it did not have this jurisdiction, and in the decision, CAT seemed to rely heavily on the fact that the alleged noise was not caused by the activities of another unit. So for instance, excessive noise from playing music or having parties. So it wasn't the activities of another resident or owner of a unit. It noted specifically that the noise the applicant was experiencing did not result from the activity of a person in another unit. The condo had taken several steps to address noise that might have been resulting from activities in another unit. So in this case, tribunal found, again, it did not have jurisdiction over the dispute. Unsurprisingly, however, how we see in a lot of CAT decisions these days, the CAT left us with a bit of a cliffhanger. In the decision, paragraph 9, the tribunal held that, having said this, I'm not ruling out the possibility that there may be situations in which a condo corporation's repair and maintenance activities constitute, quote, activities giving rise to a nuisance under subsection 117 sub 2 of the Act. In this case, the tribunal held that they were not persuaded on the evidence before them that that was the situation here. So based on a lot of the decisions that we've seen to date from CAT, noise from common elements, whether it's garages or, as in this case, plumbing infrastructure, are not noise-related disputes that the Condominium Authority Tribunal has jurisdiction over. With that said, however, there has been a recent decision that seems to suggest that if a corporation has specific provisions in its governing documents that prohibits nuisances, so some provisions usually found in the declaration, caused by or related to common elements, the tribunal may have jurisdiction to hear and determine these cases. However, in this case, there was no such provisions, or at least no such provisions were cited throughout the decision. So a key takeaway that at this juncture, with CAT still being somewhat in its infancy, it's important for both corporations and owners to properly understand where their dispute should be heard. Is it something that requires parties to mediate or arbitrate under Section 132 of the Act? Or is it something that should proceed through the courts? Or is it something that CAT has jurisdiction over? So as always, it's very important to consult your legal counsel to avoid a situation like the Di Domenico case, where the corporation, it probably incurred a lot of legal fees, taking the matter all the way up to stage 3, or at least defending the matter all the way up to stage 3, ultimately to find that the Condo Tribunal did not have jurisdiction to hear the matter. So when in doubt, consult your legal counsel.
Thanks, Natalia. And yeah, this very good advice there, because the CAT, their jurisdiction is limited to what their statutory jurisdiction is. That's the only jurisdiction they have. And so get that jurisdiction question answered early, and make sure you consult your legal counsel about that jurisdiction, because it can get very complicated, and the cases are always changing. That line is moving all the time. All right, so from jurisdiction to another noise case, we're going to have Ashley Winberg talk about reasonable steps that you need to take when you've got a complaint of noise. Ashley?
Good morning, everyone. The case that I will be discussing is Mermut versus York Condominium, York Region Standard Condominium Corporation number 1381. And this is a CAT decision where our firm represented the applicant unit owner. So I'll just go through a summary of the facts. The applicant was complaining about noise coming from a unit above. The noise consisted of banging and knocking and dropping balls, basically at all hours of the day. Much of the noise may have been attributable to a child who was residing in the unit. The corporation and the landlord of the unit where the alleged noise was coming from asserted that they had met their obligations. It had nothing to do with them, and that the noise complaints were because the applicant, who resided in the unit below, was sensitive to noise. So the applicant, the owner, they brought an application with the assistance of our firm against the condominium corporation, the owner of the unit above, and the tenant of the unit above. The applicant argued that the condominium corporation and the owner had failed to meet their obligations, specifically the condominium under the Condominium Act, with respect to enforcing the corporation's declaration and rules by not taking the necessary steps to investigate and mitigate the unreasonable noise. The tribunal ultimately found that the noise was unreasonable and a contravention of the corporation's declaration and rules, and that both the condominium corporation and the landlord had failed to meet their statutory obligations under the Act. In this regard, the tribunal noted that the corporation had a responsibility to ensure that all owners and occupants comply with the Act under Section 17. The corporation is not permitted to simply step out because they take the position that the complaints might be frivolous or that someone might be sensitive to noise. The corporation has a duty to actively and adequately investigate complaints and work towards a resolution. And the court noted that the inconsistent action of the corporation in this regard did not support the corporation's position. So what the corporation had initially done, they said, okay, we'll do some noise testing, and then they didn't follow through. And then they said, it's due to noise sensitivity. And then they would keep going back and forth. And the position that they were taking and their actions were not consistent and did not line up with one another. So the CAT found that corporation's position was inconsistent and could not be relied upon. Ultimately, the tribunal ordered that the tenant of the unit cease creating any unreasonable noise in order that the condominium and the landlord take reasonable steps as required under the Act to ensure that the tenant met this obligation. The tribunal ordered, often costs are not awarded in CAT, as I'm sure you are all aware based upon various cases discussed in previous sessions. But in this particular case, CAT ordered that the condominium corporation pay for 60% of the applicant's costs. And the CAT ordered this because condominium had ignored and missed several deadlines during the CAT application process. And they also filed late submissions, even though they were represented by a condominium lawyer. The CAT found that although this didn't cause significant delays, it did result in our client, the applicant, incurring additional legal fees as a result of having to respond to the filing of the respondent's late evidence and other procedural issues caused by the respondent's conduct. CAT also found that because the corporation essentially stepped out and told the applicant, listen, this is because of a noise sensitivity, you deal with this issue on your own. CAT found that the corporation breached its obligations under the Act, and for those reasons, resulted in the applicant incurring unnecessary legal fees. The CAT also ordered that the landlord pay 20% of the applicant's legal costs and that the respondent tenant also pay 20% of the applicant's legal costs because they refused to attend any meetings in order to come to a resolution of this matter. So the key takeaways from this decision are as follows. First, when it comes to noise complaints, yes, condominium corporations have an obligation to take reasonable steps under the Act to ensure that owners and occupants comply with the corporation's governing documents. However, that doesn't mean that a corporation can just step out when it does not have any concrete, objective evidence stating that the noise alleged is not unreasonable. The corporation has an obligation to look into both sides of the matter, adequately investigate, if necessary, seek, an experienced acoustical testing engineer to conduct acoustical testing. And when the results of that testing are finally provided to the corporation can then make a determination on whether or not, based upon the engineer's recommendations, the noise is unreasonable. If at that time, the corporation says, okay, the noise is unreasonable based upon this objective evidence, the corporation can take a side. But it is not recommended that the corporation do so prior to that objective evidence being in front of the corporation and the complaints being adequately investigated. Another important takeaway from this decision is with respect to the costs that were awarded. It is very important that the condominium corporations and other respondent owners and tenants participate in the CAT proceeding, follow the filing deadlines, and actively participate really even prior to the CAT proceeding when the initial dispute arises. Otherwise, you could be slapped with the obligation to pay a considerable amount of costs. So proactive action at the onset is always recommended. Don't be afraid to actively participate in early discussions, and do not make, if you're a condominium corporation, do not make conclusions or take any sides before you have objective, concrete evidence. I'll turn it back to you, Sonja.
Thanks, Ashley. It'll be interesting to see what CAT would say in terms of the acoustical engineer, whether there's an obligation to actually go and hire one. In this case, it seems like the condo said they were going to, and then they didn't. But it would be interesting if the condo doesn't make that promise, if that's going to be a requirement, because we do have some other case law that says that that's not the steps that a condo needs to take. So it'll be interesting to see how CAT deals with that. But ouch on that cost award. That's painful.
If you're going to say you're going to do something as a condominium corporation, you have an obligation to follow through.
Yeah, and I think that's a good takeaway. All right, so let's move on to our next speaker, Katya. She's new to our webinars. Katya, welcome to our CCI Huronia webinars for the first time. Great to have you here. Katya is going to talk about a case that deals with harassment. Take it away.
Thank you, Sonja. Good afternoon, everyone. I will be talking about DSCC 228 and Newell. So this is an application where a townhouse condominium corporation sought a variety of orders addressing Ms. Newell's conduct. So Ms. Newell's conduct began in early 2020 out of frustration over several construction deficiencies in her unit. She began emailing the board and property manager with harassing and swear-ridden emails. And let's just say her selection of words were not quite in the holiday spirit, most of which I can't even repeat here. In June 2020, the condominium's lawyer sent a compliance letter regarding her behavior, which only served to aggravate the situation. Ms. Newell began sending further and increasingly inflammatory emails and texting board members, calling them names. She uses the F word quite frequently. Ms. Newell also turned her attention to the corporation's property manager, making several racial slurs against her South Asian heritage. More incidents included playing loud music and screaming at the top of her lungs, calling her neighbors all sorts of names, throwing clay flower pots over her balcony onto her neighbor's patio, posting posters around the property alleging her neighbors, and these ones I can say were perverts and sexual predators, and enjoyed taking photographs of minor children for sexual purposes. She also enjoyed driving around the complex, yelling disparaging remarks about her neighbors and calling them pedophiles, among other names. She also enjoyed banging on the walls at 5:30 a.m. and yelling derogatory terms to her neighbors. So in January 2022, the condominium corporation thankfully commenced a compliance application against Ms. Newell, who upon receiving the application record began harassing several of her neighbors who had sworn affidavits in support of the proceeding. And while the court was sympathetic to the frustrations that Ms. Newell was dealing with, given the number of construction deficiencies in her unit, her conduct wasn't exactly appropriate. And they found that the way she was venting those frustrations was inexcusable. So the court confirmed that she had breached several provisions of the Occupational Health and Safety Act, the Declaration, the rules, and Section 117 of the Condo Act, which prohibits any person through an act or omission to cause a condition to exist or an activity to occur that is likely to damage the property or cause an injury or illness to an individual. And the court identified that the injury in this case was the psychological harm being inflicted by Ms. Newell's actions. So the court made it clear that a condominium corporation is a community that requires unit owners to live together in a harmonious fashion. The court concluded that Ms. Newell's belligerent actions and communications towards her neighbors, board members, and various other witnesses disturbed the tranquility that all unit owners are entitled to and wasn't exactly harmonious. So the court made a final order to restrain Ms. Newell's by restricting any communications with the board in writing and in a civil matter. So failing which, if further breaches were to occur, the issue of Ms. Newell's conduct and ownership in the community would be revisited by the court. So despite it being clear that Ms. Newell is not the best candidate to be living in a condominium community, the court held back on a few more severe orders, such as an order asking her to vacate the unit or being forced to sell. And this may be because she was never physically violent. However, the court did award full indemnity costs in the amount of over $73,000, noting the detailed evidence the corporation was required to bring. So this case, like the next case I will be talking about, shows the amount of evidence required to successfully bring a compliance application and receive full indemnity costs. And since the pandemic, and especially during the holiday period while people are at home and stressed, we're seeing more and more reports of the lack of respect towards managers and boards. And these cases are a good reminder that our actions do come with consequences, and expensive ones at that, because a $73,000 cost award is not a small price to pay. And I will turn that back to you, Sonja.
All right, thanks, Katya. Yeah, really important to get that evidence in order to get those costs back, because at the end of the day, it's, it's painful to win a case, but not get costs, because there's still a huge, a huge financial burden that's put on the condo. All right. And I just want to remind everybody, I think I forgot to mention this earlier, but the list of cases that all of us are talking about today, we are going to post it as a PDF when we post the video. So that will be available on our website. When you go to look at a recording of the video, you can get a copy of the PDF document that lists all the cases, the citations, so that if you want to go read the cases yourself, you can go and do that. All right, so we're going to go back to Ashley. And Ashley, you're going to talk about oppression and elections.
Very fun. So the case that I'm going to be presenting now is another one that my colleagues here worked on. It's called Gangu versus Toronto Standard Condominium Corporation number 1737. So this case pertains to, this was before the Ontario Superior Court. So this particular case pertains to proxies and the manner in which an election procedure was conducted at a meeting and how proxies were reviewed and submitted. So our clients were the applicants, they were unit owners, and they were running for election at the 2019 AGM. So this case pertains to a AGM that was held in 2019. So just before 2019, I don't know if you may all recall, those new proxy forms came into effect in 2018. So they were relatively new when this particular meeting was being held. And although they were new, the condominium corporation that put together the meeting package, they didn't put any guidance in the meeting package with respect to how to complete the proxy form, even though at that particular point in time, there was a lot of confusion in the industry, which was well known as to how they are to be completed. And it was well known to property managers and lawyers that residents who were not professionals in the industry were having a difficult time completing these forms, given that they're pretty complex and there was very little guidance provided at that time. So the applicants, they started to collect their proxies so that they could be elected for the vacant positions on the board. And prior to the meeting, the day of, they went to the on-site property management office, asked the on-site manager if the proxies that they had collected had been filled out correctly, because they were unsure. The on-site manager, looked at a couple of the proxies and said, okay, sure, it's fine. Then our clients, the applicants, took those proxy forms, roughly, I think 65 of them, and they left the on-site management office under the impression that the proxy forms were filled out correctly and that they were valid. So that evening, when the applicants arrived at the AGM, they registered with another team member of the corporation's property management staff, and they handed in their proxies. Shortly after they handed their proxies in, and before the meeting was called to order, a senior representative of the management team called the applicants aside and advised them that their proxies were not filled out correctly, they were invalid, and that they would not be accepted. So the applicants at that time then asked for their proxies back. There were, as I said, approximately 65, that they could have those owners in the building, rectify the errors and return them to them so that they could submit it prior to the election vote being called. When they requested these proxies back, they were told by senior management at the property management company that once the proxies were submitted, they were the property of the corporation and they could not be returned. Now, one thing that is important to note is that the on-site property manager never communicated to the senior property management official at the meeting that the applicants had come to them that afternoon asking for clarification as to whether or not the proxies that they were going to submit were filled out correctly. And that's stressed a lot by the court in this particular decision. Ultimately, the court found that the proxies could have been returned to the applicants prior to the vote being called. And that they should have been given an opportunity to correct their deficient proxies, given that they expressly went to the on-site property management office that afternoon to inquire as to whether or not their proxies had been filled out correctly. Another takeaway from the case was how the candidate disclosure portion of the meeting was conducted. The applicants, as I mentioned, were running for election. They did not complete and submit the candidate disclosure form so that it could be included in the meeting package prior to the AGM. So the meeting chair, who was at that particular point in the meeting, this same senior management official, asked them the candidate disclosure questions. However, as opposed to sticking to the strict question, which is, are you a party involved in litigation with the corporation, which is usually intended to elicit a yes or no answer, the senior property management official went a bit off script and ended up getting the applicants to say information that they didn't have to disclose. And this resulted, the court found that this resulted in the unit owners and attendants who had not yet voted, viewing the applicants in an unfavorable light, and as such, would reduce the likelihood that they would vote for them and elect them to the board. The court found that way in which management dealt with the proxies, in the sense that they didn't provide any guidance on how to fill out these proxy forms in advance. They didn't communicate between one another to advise that, listen, these unit owners came and asked for clarification prior to just rejecting the proxies and not returning it to them and giving them an opportunity to rectify the errors. That was fairly prejudicial to the applicants and a violation of Section 135 of the Condominium Act. And they also found that the way in which the senior property management official conducted the candidate disclosure portion of the meeting was also unfairly prejudicial to the applicants and was a violation of Section 135 of the Act as well, because it made the owners who had not yet voted view the applicants in a negative light. So the key takeaways from this particular decision, I think there's two. The first relates to proxies. Now these proxy forms have been in place for a couple of years, almost like I think 4 years at least. And there's a wide range of information on the internet as to how to fill these proxy forms out. So I generally recommend to my clients that they do include either like a sample proxy or a proxy instruction form sheet in the notice of meeting package so that residents and owners clearly understand how to properly fill out the proxy. It's also a good idea if you're anticipating that a large number of paper proxies will be submitted at a meeting, that very clearly in the notice of meeting package, you clearly state a deadline by which anyone holding over 10 or more proxies, they need to submit those proxies by. And it's usually recommended that it be, no later than, let's say, 2 or 3 hours before the meeting registration is supposed to start, because that will give the meeting chair and whomever is conducting registration to review the proxies, to see whether or not there are any errors and refer the corporation's solicitor if they have any questions. And it will also ensure that the meeting is conducted on time. At the same time, it's also important to remember that the Condominium Act is consumer protection legislation, and AGMs are the way in which owners can communicate their concerns and vote for directors to drive the direction in which they want the corporation to go. So any unit owners in terms of proxies should be given the benefit of the doubt to ensure that the democratic process is upheld. And just lastly, with these virtual meetings, a lot of corporations now costs have gone up. So they're deciding, okay, we don't want to incur the cost of having the corporation's solicitor chair the meeting, and that's fine. But it's important to ensure that whomever it will be chairing the meeting, that they have the knowledge, skill, and expertise to do so, as to ensure the meeting is conducted in a fair manner and that the democratic process is upheld. So those are my takeaways, and I'll turn it back to Sonja.
Thanks, Ashley. And, these proxies, they are never going to stop becoming a problem for condominium corporations. A good reason to do electronic voting. They don't have to deal with the proxy issue and people can change their vote if they need to change their vote. But, your points are really good. There is a process in place, and the whole idea is to give owners the right to exercise their right to vote. And so you don't want to be putting any kind of impediments in that way. And if they want to change their proxy, they have a right to change their proxy. And you shouldn't be putting up barriers to do that. So thank you, Ashley, for that. And we're going to move on to our next case. And Natalia is going to talk about status certificates.
Yeah, thanks, Sonja. So this next case was also before the Ontario Superior Court, and it's Bruce and Waterloo North Condominium Corporation, number 26. So as Sonja mentioned, this case really highlights the importance of providing status certificates with the correct information included. So this case involved Bruce, who was a prospective purchaser, and Bruce and his agent visited a unit to obtain a status certificate. In paragraph 12 of the status certificate that they were provided, it stated that the corporation has no knowledge of any circumstances that may result in an increase in the common expenses for the unit, except the corporation's fiscal year end is 2 months away, so monthly common element fees may be increased in accordance with the new budget, which has yet to be determined. The real estate agent summarized the contents of the status certificate for Bruce, concluding that the finances looked to be in order, that the reserve fund seemed to be properly funded, and that there was nothing to suggest there might be any special assessment anytime soon. Relying on the status certificate, Bruce made an offer of $535,000 for the unit, which was ultimately accepted. Bruce entered into a binding and irrevocable agreement with conditions in late June 2021. Bruce did not retain a lawyer to review the status certificate at that time and did not read all the information in the status certificate. He just relied on the summary that was provided by the agent. The agent did not mention a note in the auditor's report regarding water main repairs and the possibility of a special assessment or loan application, because it was not indicated in the actual status certificate form. The realtor said during the lawsuit that she explained to Bruce the risk of not having a lawyer review the status certificate. About a year later, in May of 2022, Bruce learned that the corporation was seeking authorization from the owners to borrow upwards of $2.5 million to repair or replace its lift station and water main. Bruce's expected share of the loan would be around $34,000 payable as part of a special assessment or as part of the loan itself. Bruce said he was unsure how long he would live in the unit and would need to opt into the loan as he could not afford the special assessment. So Bruce ultimately sues the corporation, claiming to be exempt from having to pay the special assessment or his portion of the loan on the basis that the circumstances behind the increased expenses were not adequately disclosed in the status certificate, or for that matter, disclosed at all. The court found the following facts. They found, one, that since at least 2017, the corporation had been experiencing serious issues with its water main and lift stations. This had been discussed at several condo meetings. Two, in February 2019, the corporation obtained a quote for $450,000 for partial replacement work. In May 2020, it retained consultants for the project. And in November of 2020, the corporation's auditor flagged that the corporation has tendered the water main repairs. It was unknown at the time of the audit the cost of this project, but is estimated to be significant. The work is expected to commence and be completed in the following fiscal year. To fund this project, there is a possibility of a special assessment to the unit owners and such or an application for a loan. On January 26, 2021, these audited financial statements were presented to the ownership at the annual general meeting. In March of 2021, 3 months before the status certificate was issued, the corporation went out to tender for the project. On June 7, 2021, the day before the status certificate was issued, the corporation's manager who also authored the status certificate, wrote to the project consultants seeking an update on tendering. The manager admitted in court that she asked for this update because she knew she had the issue with status certificate the next day. On June 8, 2021, the consultants replied that the tender was closing that week and they would have the results shortly. And they would provide that information to the manager. Despite this, the manager did not note in the status certificate any potential circumstances or knowledge of any potential circumstances that may have resulted in an increase in the common expenses. Bruce said that the corporation had failed to disclose material facts about an extremely expensive project that it knew about for years and was in the process of tendering for, and that he relied on the clear and plain language of the status certificate that there was no circumstance which may lead to a special assessment or a loan. He asked the courts to declare that the unit is exempt from any special assessment, levy, loan, or obligation to contribute towards the cost to maintain, repair, or replace any asset or property not disclosed in the status certificate, including the water main and lift station replacement and repairs. Bruce also asked for a declaration that the conduct of the corporation was oppressive and unfairly prejudicial, and it unfairly disregarded his interests. The corporation's position was that the status certificate contained all the material information and noted that the auditor's report made a remark about this project going out for tender. It also contended that even if an exemption can be technically provided for both the special assessment or for the loan, Bruce is not entitled to this because there's no liability on the part of the corporation. Bruce's alleged injuries result from his own conduct. Corporation said that he failed to properly review the entire status certificate package, ignoring the financial statements that indicated there may be this project coming down the pipeline. Judge Gibson, in the decision, ruled that Bruce was entitled to rely on the clear and unequivocal statement that the corporation provided in the status certificate that it had no knowledge of any circumstances that may have resulted in an increase in the common expenses for the unit. The court also held that they knew about the need for these repairs from at least 2017, and if this information had been disclosed in the status certificate, it would have flagged the potential for a special assessment or loan to Bruce. Justice Gibson said it was obvious to any objective observer that the cost would be more than the reserve fund contained and would require a special assessment or a loan. Ultimately, the judge agreed with Bruce that the act requires full sum disclosure, not minimal disclosure. He added that only with full disclosure can the prospective purchaser assess their own risk and make informed decisions about their purchase. Justice Gibson went on to say that the author of the status certificate misunderstood in thinking that disclosure was only required if the cost was a certainty and not a possibility, and Bruce was entitled to rely on the statement that there were no known circumstances that could raise his fees. The judge also noted that while Bruce was entitled to the exemption from payment of the special assessment portion or his portion of the loan, that any future purchaser would not be entitled to the same sort of exemption. It would only be applicable to Bruce. So if Bruce sold his unit, the corporation would have to know on the status certificate, and Bruce would have to inform any prospective purchasers of his unit about the special assessment or loan that was going to be levied. On the issue of oppression, the judge agreed that the inaccurate disclosure for the condo purchase was oppressive conduct. The court noted that it would be oppressive and unfairly prejudicial to impose on Bruce the cost of a project that the corporation had known about for more than 4 years, and which it knew, based on the audited statement, could result in a special assessment or a loan. So the lesson here is twofold. One, for condo corporations, it's extremely important to provide adequate status certificates that inform prospective purchasers about any sort of increase in common expenses, special assessment that they may be faced, or a loan that they may determine that is needed in the future. Even if you don't know the exact costs as of the date of issuing the status certificate, flagging it to the prospective purchaser would then require the prospective purchaser, in this case, at least, Bruce would have been required to participate in either his portion of the loan or as portion of the special assessment. The other lesson here is for prospective purchasers. If you're looking to buy a new condo unit, it's important to seek legal advice, to have them review the entirety of the status certificate package to avoid a situation like, unfortunately, Bruce had to go through. Although he was successful and he was awarded costs, he did have to spend some legal fees on his own to bring this application. So, Sonja, back to you.
Natalia, thank you. When in doubt, always disclose, and be careful with those absolute words like none, any, right? That's where you get into trouble, because that becomes like a very hard stop, and there's always possibilities. And so if you know, disclose. Thanks, Natalia. All right, so back to Ashley, and she's going to talk about shared facilities. Ashley?
Hi, everyone. So I love shared facilities, and often disputes between condominium corporations that pertain to shared facilities or reciprocal agreements, they're often resolved at mediation or arbitration. So I do like it when I see an actual case for the Superior Court. So this case was between 3 condominium corporations in the Ottawa region. 3 condominiums were built by the same developer, and they're located near each other. So the applicant was a single corporation, and there were 2 responding corporations. So there was an single electric vault, which contained an electric switchgear that was located on the applicant's land, and that switchgear and electrical vault received, managed, and distributed power brought in by the municipal hydro supplier to the 3 condominiums. There was no shared facility agreement between the 3 condominiums. However, the consumption of the hydro was separately metered. The switchgear at issue was over 30 years old. It was well past its useful life, and was at risk of failing. And if it did fail, it would leave the 3 condominiums corporations without heat and without power. So just before, in October 2021, it had failed twice, and what I'll call is the applicant condominium corporation paid to replace it. And then they never asked the other 2 responding corporations to share in that cost, nor had they ever. The applicant condominium corporation finally obtained proposals for a replacement of the dated and failing switchgear, and the costs were a little over $150,000. And the applicant condominium corporation turned to the other 2 condominium corporations and asked them to contribute the cost, which they initially refused. So the issue before the court was whether the applicant condominium corporation could pay for the entire cost of replacing this shared component, in addition to all past and future repair and maintenance costs, or whether these capital repair and maintenance costs should be shared by all 3 condominium corporations, even though there was no shared agreement between them. One thing that is important to note, that all 3 of these condos were dependent on this component to supply and direct power to them. There were 2 dedicated switch breakers, one of which provided power exclusively to one of the responding condominium corporations. And that responding condominium corporation was the one that adamantly refused to contribute and pay for the costs associated with the repair and replacement. The other condominium corporation, once the case finally came before the court, advised that they were willing to share a portion of the cost based upon the number of units. So the condominium corporation that was refusing to share or pay anything relied on the fact, stated that there's no shared agreement, and in the declaration of the applicant condo, they have an obligation to repair and maintain its common elements, which included this particular switchgear. So the applicant argued that all three corporations have an obligation to contribute based upon the doctrine of unjust enrichment, which is a legal principle, and there's 3 steps. And this doctrine of unjust enrichment often comes up in shared facility disputes when a shared asset needs to be replaced, or if there's a considerable cost that needs to be incurred for which there isn't anything written in stone yet as to how it's supposed to be paid for and shared, if any. So the doctrine of enrichment has 3 things that need to be met. There has to be a benefit, there has to be a corresponding deprivation, and there has to be no reason for the benefit and corresponding deprivation, which is called the juristic reason. So there clearly was a benefit here. The defending or the responding corporation was receiving the benefit of heat and hydro. There was a corresponding deprivation in the sense that the applicant Condo was paying for all of this maintenance and repair for all these years, and upon replacing this switchgear would be paying for it if the corporations didn't all share the cost. So the issue then turned to whether or not there is a reason for this benefit, a juristic reason for this benefit and corresponding deprivation. And there is a particular test that the responding parties are supposed to show to say, okay, yes, there is. And they can often rely on, listen, there's this contract that states this, and that is the reason why we are entitled to this benefit, and there's this corresponding deprivation such that the other party is not unjustly enriched. So the responding condominium stated that there is a juristic reason for this unjust enrichment because there's no shared agreement. And also clearly states it in the declaration of the applicant condominium that they have an obligation to repair and maintain their common elements, period. That's the reason for the corresponding benefit and deprivation. The court ultimately did not buy that argument, and they found that there was no juristic reason and that there was an unjust enrichment, and ordered that the 3 condominiums proceed to mediation arbitration to determine how the cost would be shared among them. And the court rejected the arguments made by the responding condominium because the court found that just to say that there's no shared agreement isn't sufficient. If that was the basis upon which this legal principle is based, it would defeat its entire purpose. And also, although this condominium is speaking to the rights and obligations in the applicant condominium's declaration, those rights and obligations are between that condominium corporation and its owners and its residents. It doesn't apply unless it's specifically stated to an outside party like this other corporation. So the 3 corporations were ordered to determine how they're going to be sharing the costs. And it is important to note that it was also mentioned by the court in this particular case that Condominium Act has a pending amendment which requires that condominium corporations enter into shared facility and reciprocal agreements exactly for this purpose. However, that particular amendment has not yet come into force. It was originally drafted, I believe, in 2017, 2018, and we're still waiting for it to come into force. It's not yet law. However, if your condominium shares an asset with another condominium or an apartment building or a neighboring property, I strongly encourage you to see if there's any existing agreement in place, review it to make sure it's reasonable and clear. And if it is not, and if there isn't one that exists, start negotiations and trying to either draft one to put one in place or amend one that your condominium feels is unfair or ambiguous. So those are the takeaways from that particular decision.
All right. Thanks, Ashley. And, I find it so baffling that case went to court, because I don't know how a condominium can stand there and say, well, we get a benefit, but we don't want to pay for it. Like this is a case that should never have gotten before the courts if everybody was acting reasonably. So one of those baffling cases. But anyway, we are slowly running out of time. Well, we're quickly running out of time, actually. We're going to be running a little bit over our hour mark today. So we still have a couple more cases to discuss, but I just want to remind everyone that if you are a condominium manager and you want to have confirmation that you attended today's webinar, please make sure you put your name and company name in the chat box. That is going to be our record of your attendance today. And I hope you stick around to hear the last 3 cases that we're going to discuss. But if you don't and you can't and you got to go, we hope to see you in the new year. We will not be having a webinar in January. Our webinars will start again in February 2024. Always check our website, ccihuronia.com, for our list of upcoming events, for the dates and times of those events, and to register online. So let's go back to Katya, and Katya is going to be talking about, this is an interesting case because it deals with substance abuse, somebody who's abuses a substance and obtaining compliance. Katya?
Thank you. Yes, so I will be talking about TSCC 2581 and Paterno. So this is an application against Mr. Paterno, who the court describes as an intimidating appearing man who owns 2 American bullies resembling pit bulls and who has a history of substance abuse issues. From his purchase in 2016 to 2021, Mr. Paterno had been managing his substance abuse well, with little to no complaints having been ever received. However, commencing in 2021, Mr. Paterno began exhibiting, as the court put it, unacceptable misbehavior linked to a lapse in his substance abuse management. The court describes his behavior as aggressive, rude, profane, and disrespectful. Despite compliance letters, Mr. Paterno's offensive behavior continued. He would make sexually explicit comments to female employees, and as a result, many property management employees requested and were granted reassignments to other properties. There were also incidents of Mr. Paterno screaming and shouting and uttering death threats, which were investigated by the police. Incidents also involved Mr. Paterno stripping down in the elevator and showing his genitals to the security camera. Mr. Paterno was also charged in criminal proceedings after he punched and shattered the plexiglass surrounding the concierge desk and proceeded to verbally and physically assault the concierge. I could go on. Mr. Paterno engaged in all sorts of conduct, including abusing and threatening contractors, allowing his large dogs to run free and soil the common elements, and refused to abide by COVID-19 protocols, and for instance, breaking into the pool and going for a little swim. He also accosted other residents and destroyed their property. So the condominium corporation commenced a compliance application against Mr. Paterno, seeking a declaration that Mr. Paterno was in breach of sections 117 and 119 of the Condo Act, the Condominiums Declaration, and the Occupational Health and Safety Act. The condominium corporation also sought for Mr. Paterno to vacate and to be forced to sell his unit. Courts have often been hesitant to make these types of orders, and in the past, courts have described the necessary circumstances required to force an eviction and the sale as a perfect storm. And this case is a clear example of just how hesitant they are and the high threshold that is required to obtain this kind of order. So despite the court recognizing that condominium living is communal living, residents must live by the rules of the community and must behave themselves with respect and consideration for their neighbors. Also, despite that the court recognized that where the behavior of a resident is antisocial, disruptive, unacceptable, or ungovernable, the condo may seek from a court an order to evict and force the sale of the unit. And despite the court even confirming, and I quote, that unless he gets his substance abuse problem under control, he is likely to cause damage to the property of the condominium corporation or to the property or persons of other residents of the condominium community in the future. Despite all of this, the court determined that his immediate eviction and an order for him to sell his unit was too harsh a remedy for his wrongdoing. The court found that Mr. Paterno should be given an opportunity to rehabilitate himself, as he expressed remorse during these proceedings, and to prove that he could be a responsible member of the condominium community. Ultimately, the court granted what they described as a conditional zero tolerance eviction order. This decision serves to illustrate just again how courts continue to view eviction and forced sales as extremely harsh remedies that they are reluctant to grant. And in most cases, the condo will need to show that the lengthy history of bad conduct is incorrigible and unmanageable before a court will order that sale of a unit. And as with most issues in condos, dealing with difficult owners is a long and arduous process, and it's important to manage expectations on the relief that can be reasonably sought. One would have thought that Mr. Paterno's case was the perfect storm, allowing for that forced sale and eviction, but here we are. It was not awarded in this case.
Thanks, Katya. And, again, this is a great illustration of, the extremes that a condo has to go to try to get someone to be forced out of their unit. It's very, very difficult. Although it's extremely frustrating to have to go through this process. And at some point you wonder, when is enough, especially, in light of, the tragedy that we had to deal with last year in Vaughan and the shootings in Vaughan. It's just, sometimes you just got to shake your head, and you kind of want the judges to be living in these condos for a while to realize how important it is that something gets done, and that, there's only so much a condo can do. And we really are pleading with the courts to try and take some action that will relieve the situation for all the other owners. So sad case to see that, again, they're not prepared to do that, but hopefully we'll be getting some cases in next year that maybe would support condos a little bit more and or make those orders in the right circumstances. All right, back to Natalia. So as I said at the beginning, there is no case law update without talking about some kind of pet and a support dog. So Natalia, you're going to talk to us about support dogs and restrictions.
Yeah, so this next case, York Condominium Corporation number 288 and Tamhain, our office actually represented the respondent, which was a tenant. There was another respondent in the file too, which is the owner, but they didn't participate in the actual application hearing at all. So this case before the tribunals sheds some light on what corporations shouldn't do when they're faced with concerns about an emotional support animal. So the applicant condominium corporation is a residential condo corp, and in its governing documents, it prohibits all pets. In October of 2020, the respondent tenant made an accommodation request under the Human Rights Code to have an emotional support dog, which would otherwise be in contravention of the corporation's governing documents. In support of his request, the respondent provided the corporation with 2 substantive medical notes. I know a lot of times we see these notes from these odd agencies that probably pay $25 to get this type of medical note written. However, here there were actual medical notes from acting physicians that substantiated his need. So in November of 2020, approximately a month after the request was made, the request was approved by the condominium corporation without any restrictions on the breed, size, weight, etc. of the emotional support dog. In December of 2020, the respondent brought in his emotional support dog and moved into the corporation. In its approval letter, the condo corporation indicated that it would provide a list of conditions to follow in about 2 weeks' time regarding the emotional support dog. No list of conditions was actually provided to the respondent tenant until approximately March of 2022, so about 1.5 years later after the initial approval, the accommodation was granted. In March of 2022, the condo corp provided the tenant with this list of conditions out of nowhere and just unilaterally imposed on the respondent these list of conditions without his consultation or without any sort of discussion with the tenant respondent. As part of the restrictions, the respondent had to muzzle the dog while on the common elements. He had to also have the emotional support dog complete certain training by a specified date. And there was a restriction about where the respondent could enter and exit the building with the emotional support dog. And in this case, it was a north service corridor and a north bank of elevators that was nowhere near his unit. This is a fairly large condo corporation right in the middle of downtown Toronto. Another restriction unilaterally imposed is that the emotional support animal could not be taken anywhere else on the common elements. The Condo Corp had some concerns relating to the emotional support dog's conduct. There was allegations that there were incidents of the dog lunging at others on the common elements or lunging at other dogs on the property. And the respondent was also not complying with the restrictions imposed, particularly which entrance and exit they were allowed to use with the emotional support dog. There was also some minor complaints about the dog barking and causing excessive noise. So ultimately, the Condo Corp brought an application before the tribunal seeking one, an order for the removal of the respondent tenant's emotional support dog, or in the alternative, if the removal wasn't granted, an order that the respondent tenant comply with the list of conditions that they imposed in March of 2022. The Condo Corp argued that the dog posed a significant safety risk within the condo because of 3 alleged incidents of lunging, 2 of which the Condo Corp provided security footage to the tribunal, and several noise complaints about the dog barking. The condo argued that they could no longer accommodate the emotional support animal because it posed undue hardship on the condo corporation. The tribunal disagreed. The tribunal found that the accommodation for the emotional support dog did not pose any undue hardship. In evaluating the evidence, the tribunal found that the 2 incidents of the alleged lunging, which the security video was provided, did not establish that the dog had acted in any aggressive or unreasonable manner. In fact, the tribunal held that the aggressor in one of the videos was actually another dog, not the emotional support animal. The tribunal also favored the respondent's evidence in terms of the barking allegations or the noise allegations. The respondent produced multiple letters from its neighbors confirming that they either do not hear the dog barking or they're not bothered by occasionally hearing the dog bark. Additionally, the respondent provided evidence from his Furbo, which is a device that notifies the tenant when the dog was barking for more than a minute, and this Furbo evidence provided that there's no notifications of any barking incidents. The tribunal also found that the Condo Corp had failed to adhere to their process for addressing serious incidents before commencing the application. The tribunal denied the applicant condo's request for an order for the removal of the dog, and also the tribunal denied the applicant's request for an order enforcing the list of conditions. The tribunal held that the Condo Corp did not engage in any discussions with the respondent prior to unilaterally trying to impose this list of conditions. They also did not discuss their concerns about the emotional support animal with either the tenant or the owner. So the tribunal also held that the Condo Corp had failed to comply with its procedural duties under the Human Rights Code by failing to engage in discussions about their concerns with the accommodation for the emotional support dog and any of the allegations that they were trying to make before the tribunal. As a result, the tribunal dismissed the application and ordered that the Condo Corp reimburse the respondent for 60% of his legal fees, so just over $9,000 that the corporation had to pay to the tenant. So some key takeaways from this case is when evaluating a resident or an owner's accommodation request, condo corporations should conduct their proper due diligence, obtain advice from legal counsel if required, and most importantly, ensure that there is an open dialogue and discussion with the accommodation seeker. And if there are any subsequent concerns regarding the accommodation or the emotional support animal, to continue those open discussions and to take appropriate and reasonable steps before commencing applications against the accommodation seeker. Another key takeaway is the importance of condo corporations to implement standardized policies for accommodation requests, so an accommodation policy. And this will provide a unilateral approach for corporations to address any sort of accommodation that owners may be requesting or residents may be requesting. And thirdly, when accommodation is provided, it's important to outline what certain restrictions and obligations the parties may have through accommodation agreements that are approved by both parties, rather than unilaterally imposing restrictions on an accommodation seeker years after the accommodation was approved. Sonja, I'm sending it back to you.
Thanks, Natalia. And those are some really good pieces of advice there and takeaways from that case. I'm going to, I have one case that I'm going to talk about today. It's a very recent case from CAT, and it too deals with a dog and accommodation. But the key takeaway from this case is making sure you have proper evidence when you are making decisions and not making decisions based on your own beliefs. Without having some independent evidence to support that. So this case is called York Condominium Corporation 435 in Condo. It's a decision from November 28, 2023 from the CAT. And very briefly, the Condominium Corporation has in their rules and declaration, no dogs are allowed. The owner was seeking accommodation under the Human Rights Code for a dog to be permitted. The owner had some really good evidence. And, a lot of times I've dealt with these cases over and over again. A lot of times the owner, gets one of these like very simple notes saying needs a dog for medical purposes. And that's it. And that's all you get. But in this case, the owner actually had some really good evidence from 2 doctors and also from the person that she was getting the disability, the dog that was trained to deal with her disability specifically, from that company, the owner and trainer of that company. On the other hand, the condo's evidence was from the condominium manager and a director, both of who acknowledged they are not experts in terms of disability-related needs or what dogs are appropriate. Now, the condo at first didn't approve the dog as a need, but then later came around and agreed that the owner needed a dog for a disability. And the dispute really was about what kind of dog. The owner ended up getting a white German Shepherd. That's what the disability trainer recommended for her based on her specific disability. And the board just felt that the German Shepherd wasn't an appropriate dog. They actually put a restriction in a rule after all this started saying German Shepherds weren't allowed, but they had no basis on which to make that restriction. They had their own beliefs as to why German Shepherds shouldn't be allowed, but there was no objective evidence from some kind of expert who could support the beliefs that they had and the basis of their decision. So at the end of the day, long story short, the tribunal allowed the dog. They said that the board did not act reasonably and they did not accept the business judgment rule applied in this case because the board wasn't acting reasonably. And the other thing that is interesting in this case, and Natalie talked about it in her case about these accommodation agreements, the condo wanted an accommodation agreement to be a term of the order if the dog was allowed, and the tribunal did not order that. So at the end of the day, the really important reminder here is that when you are dealing with someone who is making a request for accommodation, if you are going to deny that request and they've already provided you with some evidence to support that request, you cannot deny that request just on your own beliefs. You are going to need to go out and get some evidence to support the beliefs that you have. Otherwise, when it comes to the tribunal, if you look at the weight of the evidence, the owner's got substantial evidence, 2 doctors, a specialist in training for disability-related purposes, and the owner's own evidence about her needs versus the opinions of a director and a property manager who has no special skills in this area. And, obviously the evidence of the owner is going to outweigh the evidence of the condo corporation, and the condo is going to lose. So that's a good takeaway from this case. It's a good case to read. It provides you with a lot of information about what condos should do when dealing with these types of requests. And at the end of the day, look at the evidence, rely on evidence, not on your own beliefs or opinions. Okay, so that wraps up today's webinar and our 2023 case law update. I want to take this opportunity once again to all of you that stuck around. I know we ran a little bit over time, but thank you for sticking with us. And I also want to take this opportunity once again to thank our sponsors. And I'm just going to share my slide here. Thank you to Integrity Property Management, Nordic Windows and Doors, and Select Path Insurance. Again, without their support, we're not able to offer these webinars free of charge. So we thank you for supporting CCI Huronia and supporting all of our participants so that they can continue to educate themselves on condominium related matters. Also, don't forget to check out our website under the events tab for our upcoming events for 2024. We have all the dates set for our webinars for 2024. But the topics have not been finalized yet. So if there is a topic that you want us to cover, please send us an email to admin@ccihuronia.com. Tell us about the topic and what it is you'd like to learn about, and we'll see if we can incorporate that into our webinar schedule. Don't forget, there is no webinar in January. But our webinar, Lunch and Learn webinar series will start again on February 23rd at 2024 at 12 noon. But in January, we are holding our Intro to Condo course on January 24th. This will be a webinar. It'll be an evening webinar starting at 7 p.m. So if you know anybody who wants to just take a general introduction to condos, this is a great course for that. You can register online at our website, ccihuronia.com. Also in February, we'll be running the Director Certificate Program Course 102 called Insurance Fundamentals. So if there's any directors out there working towards their certificate, we are running the 102 course in February. So if you're not on our email list, because that's how you're going to find out about what's happening at CCI Huronia, be sure to send an email to admin@ccihuronia.com. Ask to be put on our list. We are more than happy to add you. And then you'll get information about upcoming events, the release of our newsletter, and anything else that's happening in relation to CCI. Also, you can always check out our website, ccihuronia.com, for upcoming events. Don't forget, all of our webinars go from 12 to 1. A recording of today's webinar will be posted on our website as soon as it's available, and we will also be posting a PDF document that will contain a list of the cases that we referred to today and citations if you want to go take a look at the cases yourself and read them yourself. Don't forget to join us on Facebook and on LinkedIn. Don't forget to subscribe to our YouTube channel. And this is your last chance. If you are a property manager and you have not put your name in the chat box, please don't put it in the Q&A box, put it in the chat box. If you haven't put your name and company name in the chat box to confirm your attendance, this is your last opportunity to do so. And check out some of the events happening at our other chapters across Ontario. CCI Huronia is doing the Director Certificate Program 103 on January 18th, Budget, Audit, and Financial Fundamentals. You can go to their website, ccitoronto.org, to register. CCI London is doing a course on conflict resolution in condos on January 16th. You can go to their website, cci-sw.on.ca, to get more information. Our friends in Grand River are doing the Director Certificate Program 101, the Governance Fundamentals course, on January 24th. And as always, you can always check out the CCI national website, cci.ca. There is a list of courses that are running from coast to coast at all of our chapters across the country. If you just click on the website and scroll down to the bottom right-hand corner, there's a list of upcoming courses there that will provide you with a link directly to those chapters, and you can register for those courses. So until next time, I am Sonja Hodis, and from the entire CCI family to yours, wishing you a happy holiday season, however you may celebrate it. And we hope to see you at our next webinar in February and at all of our webinars in 2024. And don't forget that CCI is your condo connection. Thank you, everyone.